Good afternoon, Mr. Pate. Good to see you.
Good afternoon, Your Honor. Stephen Pate of the Rutherford County Bar for the appellant, Jeremy Nathaniel Greene. I'd like to reserve 2 minutes.
2 minutes, yes, sir.
Two issues raised in our brief. The first issue is whether the trial court erred in the determination of the value of the entire marital estate, and then whether the trial court created an inequitable division of the marital estate. Now, as addressed in the argument, there's what I call a sub-issue, not numbered as such, as an independent issue, but a sub-issue regarding the court's determination of credibility of the parties, which is very critical in the court's final division of the marital estate. Regarding the first issue, regarding the division of the marital estate primarily consists of exactly 16 acres and a marital home. In Wife's Rule 1030, that's the Bedford County Local Rules of Practice Income Expense Statement, in the Wife's Rule 1030, she valued the home and land at exactly $808,000, which resulted in equity of $457.72. She later amended that opinion, raising the value to $817,000, resulting in equity of $474,118. This opinion of the wife was based on an opinion only and was not based upon an appraisal. Husband opined that the home and 16 acres was valued at only $50,000, and with the payoff between $330,000 and $340,000 resulted in a total equity of $180,000. If divided equally, will be $90,000 per party.
So you really meant 500,000, not 50,000.
I'm sorry,
Yeah.
I said 50. I stand correct. Yes, sir.
Right.
I apologize. 500,000, not 50,000. I'm sorry.
Okay.
But the husband's opinion that the home and land was valued at $50,000 was based on one piece of evidence to support his position. There was a settlement statement upon the last refinancing of the home and acreage, and the settlement statement confirmed that the bank was of the opinion that the property was worth $500,000.
Was that excluded from the evidence?
No, sir, it was not.
Okay.
Again, he opined that in his opinion, as a co-owner, the property was worth $500,000. But there was a settlement statement that confirmed that exact fact. Now here is where the issue of the credibility turns, because at that point, the trial court, Judge Cox, Chancellor Cox, opined sua sponte, that it found in favor of the wife regarding credibility and gave her full credibility on her opinion as to all assets constituting the marital estate, and basically ruled that the husband was less credible. Now, in the division of the marital estate, that is fatal to in this case, to my client, the appellant husband, because it means the court can base its opinion exclusively on credibility and on little else. The problem is the court came to that conclusion sua sponte with no basis of fact. I don't know there's a statute that says you have to have the findings of fact and conclusions of law, but it seems to me logically you need to have some basis of fact to support credibility.
Well, are you suggesting that the wife's testimony regarding value of the various property was not competent evidence?
It was competent evidence, yes, sir. Her opinion.
And as you point out in your brief, I mean, the court was free to select between
Yes, sir.
the range of competent evidence here, and, you know, perhaps saying it was based on credibility was probably not the most artful way of saying that, but I mean the court certainly had said, made no distinction about credibility, but just said, I am accepting Weiss' valuation. I mean,
but he did more than that. He literally used the term, I am giving more credibility to the wife and less credibility to the husband, and again, rather sua sponte, and not based on any statement of fact or findings of fact. So we don't know why the court came to that conclusion. Now, consistent with the court's opinion on credibility, the parties maintained a joint bank account with U.S. Bank, balance of $12,872. The wife admitted that she had depleted that account to the extent of $20,000 during the party separation, so the resulting balance was somewhere between $12,800 and $13,300. She had depleted it to the extent of $20,000, and the court basically gave husband no credibility for that, and otherwise the court divided that account. But with no credit to the husband for the wife's expenditure of $20,000. Second account, husband's personal, his Amazon account, of course that's marital property. Wife conceded that she spent at least $3,176 from the husband's account. Husband said no, he thought she spent between $7,000 and $9,000 from that account. And basically, that account was equally divided between husband and wife with no credit to the husband regarding wife's expenditures. Now, there was a 401k account in the name of wife, but marital property. She conceded that she withdrew $14,000 from the 401k with Fidelity to use exclusively as attorney's fees, exclusively. Wife was basically allowed to keep the balance of that account with no credit to the husband for the expenditure of the $14,000. Half of that, or $7,000, should have been credited to the husband for attorney's fees. The court gave him no credit for the $7,000 for any portion of the $14,000 withdrawn, and allowed wife to keep the remaining portion in its entirety. Husband's account with Voya, V-O-Y-A, was almost exactly $12,000, was equally divided. Now, in summary, the court determined the value of the total marital estate was $704,201. Wife received, as per the court's order, 57% of that, which was $400,528. Husband received 43% of $303,673. There's no issue that 57 versus 43% is not inequitable per se, of course, under theories of equity. But the husband's main complaint is the estate was grossly overvalued. His opinion is the estate should have been a total of $387,201, with wife to receive $242 and $28, 63%. Husband to receive $145,173, or 37%. So under the husband's theory, wife would receive a higher percentage, 63 versus 57. Husband would receive a lower percentage, 37 versus 43. But the huge benefit to the husband is the estate is valued significantly lower, so he owes wife less money. It's just that simple. The second issue is the attorney's fees. Keep in mind in this case, the parties, this was only a 10-year marriage. The parties were approximately of the same age, the same educational background, the same earnings during the 10-year marriage, and clearly having the same potential earning capacity in futuro. Number two, as this court is well aware, attorney's fees are basically a form of alimony in solito. This is not an alimony case. It never was, and it couldn't have been an alimony case based on those factors that I just described. But notwithstanding that theory, not only did the wife receive $14,000 from her 401k, half of that should be credited to the husband, the court awarded her an additional $31,368 in attorney's fees. So depending on your math, at a minimum, her attorney's fees exceeded $38,000 if you factor in half of the 14. If you factor in the full 14, it's $45,000 in attorney's fees, but at a minimum, it's $38,000 in attorney's fees in a case where the wife had the clear ability to pay her own fees from the division of the marital estate and from her earnings. Again, this was never an alimony case. It was never an issue in alimony. So how the wife jumps from a non-alimony case to suddenly attorney's fees exceeding $38,000 is a mystery to me, mystery to my client, and I don't know how the court came to that conclusion other than to simply he overvalued the marital estate. And again, once he uttered those magic legal words, credibility or lack thereof from the husband, then that is almost dispositive. The court can do whatever it wants with the estate to say, I credit the wife's testimony, and I discredit the husband's testimony. But on one particular point, we have some objective evidence to wit. There was a bank closing statement that said the home was worth $500,000. The husband said, in his opinion, $500,000. The wife has it at $830-something thousand. Very simply, there's a long line of appellate decisions that state very, very clearly that while equity doesn't mean equal, if the court reaches an illogical or unreasonable decision, or the decision is based on clearly erroneous assessment of the evidence under Tefler versus Tefler 2018 Court of Appeals decision, the trial court was simply wrong. The trial court is subject to reversal. And that's exactly the situation here. If you look carefully, I think we filed a spreadsheet and then an amended spreadsheet to correct some errors on the first spreadsheet. I mean, the wife's proportion of the marital estate is grossly out of proportion to the husband's, but in particular regarding the valuation of the properties by the trial court. And then again, as I stated, with the court allowing wife to retain the balance of her 401k and the husband's 401k being equally divided. I mean, legally, in plain language, what's the logic of that? It just shouldn't have happened like that. It just ended up being one-sided, and for no reason other than, as I say to the court, uttering those magic words, credibility. That being, frankly, in my opinion, dispositive of these issues. So for the reasons as set
Mr.
forth.
Pate, what is the earning capacity of the two spouses? I thought I had it written down and I don't see it.
I don't recall, and I don't want to.
You indicated that they were basically equal.
Equal. I don't want to recall, excuse me, I don't want to misstate a fact.
But they both worked outside of the home for
Yes,
years.
sir.
And
A 10-year marriage, equal age, both in good health, no disabilities, both worked outside of the home and earned an approximate equal income. To wit, that was why it was never an alimony case from its inception, and today it's not an alimony case.
But she did make a prayer for attorney's fees, though, didn't she?
She did make a prayer for attorney's fees, but that's, from my experience, in every single domestic pleading for attorney's fees. But again, if attorney's fees are equivalent to alimony in solito, you have to judge it based on the alimony criteria, and there's no need. And husband has a limited ability to pay, but first and foremost, if there's no need, irrespective of husband's income, she shouldn't receive alimony.
Thank you.
Yes, sir.
Let me ask you,
Yes, sir.
if you back out the equity in the home, what was the total value of the marital estate, and what percent did the wife receive, and what percent did the husband receive?
Husband's argument, this is addressed in the brief.
Keep in mind, I'm backing out that $400,000 from the sale of the house, or the supposed equity in the house.
Husband's value of the entire estate, including his opinion that the home and land was worth $500,000, brought the value of the total marital estate down to $387,201, where the wife opined that the value of the estate was $704,000.
But that includes the $450,000
Yes,
worth of equity. See, I want you to back that out for me. Have you done that at all?
I'd have to get a calculator to back out the difference between the two figures.
Okay, all right.
I
Don't
can't
worry
tell you
about
that exactly.
Okay.
I'm sorry.
All right.
Yes, sir. Thank you.
Thank you. Mr. Hornsby.
Afternoon.
Good afternoon.
Hopefully Judge Armstrong doesn't have PTSD see me twice today. I'm here representing the appellee in this case, Laura Greene, who's decided to attend this matter. But here's the big issue. Mr. Pate nor I were present at the trial. We were not the trial attorneys. I mean, you put our education and our experience, we got a lot of years. But what happened is another attorney showed up and he's going through the record. I'm gonna have to go through some misstatements he made. He's fine enough attorney, he wouldn't do it intentionally, I do not believe. But the brief that they filed was woefully inadequate. There's a rule out there now called Rule 7. You all know about it. You're supposed to go through and list it. When I went through their Rule 7 statement and I looked for the court's determination, which is supposed to be in there, it's not there. When I looked for separate property, it wasn't there. No separate property was listed. We know he had a retirement before he was married. They didn't value it, didn't put it in there, didn't address it. They didn't address the debts. We knew her car had a debt on it. We knew there's a huge debt on the house. What they did was they kind of threw a number out there, which was their determination of what the equity should be, without saying this is the fair market value, this is the debt on it. We would respectfully submit it is woefully inadequate. They listed the 55-acre transfer to the parent. That was a dissipation of assets that happened right before the litigation. He got her to sign a deed transferring 55 acres to his parents, arranged by his mother, paid by his mother, giving this 55 acres to them so that they could work on their marriage, during which time he was seeing his girlfriend getting a divorce already ready. Now, we didn't raise the issue and bring his parents in because the court made findings that I think really are pretty hard for me to try to overturn. So we didn't raise that issue. But there was a significant dissipation. They listed that. They did not list the separate property, didn't list any marital debts. And here's the issue. The court found her more credible. And there's significant reasons. When you go look at what he went at the trial, he showed up totally unprepared. Mr. Pate would not have had his client shown up that way, but Mr. Greene did, because he wanted to put in an appraisal. Here's an appraisal, objected to, hearsay, sustained by the judge. Definitely, no appraisers there, nothing there, they just want to put it in. They even cite it to their brief, but it's not in the evidence, it wasn't admitted, no offer of proof was made, and he was asked a specific question. How much is the value and the debt on the property on 2 different times? In his testimony, volume 1, pages 78 and 137, he said, I have no opinion as to the value and the debt. That's what his testimony was. I have no opinion. Now, he came out with a different number here. Later on, I'll have to acknowledge, he said it's worth at least $500,000. That's it, at least. Well, her testimony was at least $500,000. It was $800,000, a little over $800,000. But he came in totally unprepared.
Let me ask
Yes, sir.
you, other than her testimony about the valuation of the marital property, the house,
Yes, sir.
was there any other proof concerning the possible value of that home in 16 acres?
No, sir. It was her testimony and his testimony.
And that house was built on 16 acres?
Yes, sir.
As I understand it.
Yes, sir.
And the value of that acreage had to be less than $30,000, right?
I do not think there's anything in the record to reflect what the property values are in Bedford County, Tennessee at that period of time.
Yeah, but we know that they paid $110,000 for 66 acres. And if you knock off 16, that would be an average price, really less than $2,000 an acre, wouldn't it?
It would be, given there were no increases in property values.
Well, was there any proof in the trial about how property increases in value in that county?
No, sir. There was no proof. It was literally her testimony versus his testimony.
And what was the cost of construction of the house?
That wasn't included either.
Nobody testified that they made a loan of
No, sir.
$400,000?
We had the loan amount. And if you look at our Rule 7 statement, it was, at the time of the trial, $342,881.
But the loan amount to construct the house was how much?
That was not included in the record.
So there's nothing in the record that says that they made a loan of $400,000.
Or $500,000, or they put down $100,000. Nothing of that was included.
Well, I'm just trying to figure out, how does a house where you make a loan of $400,000, we don't know that they used all of that to build a house, on land worth approximately $25,000, so you got $425,000 into it. How does that increase to $817,000 over a 2-year period?
It depends a lot on the value of the house, and that's the big unknown. I mean, we know what the square footage was. We don't have any bedrooms and bathrooms.
Well, I'm trying to figure out,
Yes, sir.
why would the judge conclude, just from her testimony, that it's worth $817,000?
Well, it's $818,000, but yes,
Well,
because.
the order says 817.
But I apologize, I may have.
Let's say 818, whatever.
It's not worth arguing over, yes, sir.
Okay. What is that based on?
Because if you look at the rest of her testimony, when you get to her Ford Escape, he comes in and says, well, it's worth about what's owed on. Then he says it's worth either $1,000 or $2,000. They cite $2,000 in their rule. So she comes to court and says, no, there's equity of over $2,000. I mean, she would have been better to sit there and say, no, it's worth what's owed on, just like he had said.
So are you telling me if she had said that the value is $1 million, that the judge could just accept that based on him having found her credible?
Well, I would say that if Mr. Pate and I were the trial attorneys, there would have been a lot more evidence submitted than there was. But we're stuck with the hand that we're dealt. And the hand that we're dealt is, she came in and said, it is worth this amount of money, the loan is this exact amount, and then he said, I don't have an opinion.
Well, are you curious about the judge's ruling at all, where he says, all right, husband, sell the property, and I don't care what you get, you still got to pay her as if the value is $817,000. Why would a judge rule that way?
Well, because otherwise, I guess he'd have to hold on to that case for many months more, and you wouldn't have a final order, because he'd have to sit around and wait on it to determine what, I mean, if he sold it for $900,000, I'll use that example, he would have benefited. If he had sold it for less, then it was to his detriment.
Do you think it's likely that he would have sold it for $900, or would it be more likely that he only may get $500?
I don't think it's likely to know what he would do, because he was under an order to try to refinance the property. He didn't do that either. He never did. He's just living in the house, wants to stay so he can live in the house that he's been living in the entire time to this litigation. And we're dealt with the hand. I mean, normally Mr. Pate and I would have had 2 appraisers there with 2 expert opinions, with a bunch of appraisers, and then the court would look at that. But we had one guy that says, I don't know, versus her saying it's worth this. So what is the court supposed to do? Is he gonna come out to some other number? If he came out with any other number, then I think both of us would sit there and say, well, how did the court come to any other number? If it came up with $700,000 or $600,000, there's nothing in the record to support anything other than 800, and I don't know. And when you go through the other items, he was that way the entire time. He did not know values of anything. He was asked questions. How much is the U.S. bank account 0184 worth? I don't know. How much was the U.S. bank account 9847 worth? I don't know. That was his answers. She came in and said, later it is 10,000-ish. I like to heat it, ish. And then later on the brief, they cite a different number, but the cite doesn't attach to an exhibit that was introduced in trial. It was an exhibit that was marked for identification purposes. So we respectfully submit, you got one lady who's very accurate, very meticulous, is able to tell you exactly what the amount is worth, exactly what the loans are worth, versus a guy that comes in and continues to say, I have no idea. I don't know, with no appraisers. So, and I go with one statement that Mr. Pate said, my client said she spent $20,000, acknowledged $20,000 in furniture and assets. This was the question. Would it surprise you if you spent $20,000? She said yes. That doesn't mean I admit it. It says it would surprise me if you say. So she didn't even acknowledge the $20,000, but they're up here arguing She acknowledged 20,000. The question asked was, would it surprise you if the amount was 20,000? Her answer was yes, and his testimony was 79,000. But then the court pretty much said, you made all these purchases by agreement. She agreed to them, he agreed to them, they discussed it, and we're just gonna, they're relatively minor, so we're gonna keep it out. We would respectfully submit the attorney's fees are appropriate. They didn't make the exact same amount of money. I went through my brief. She makes $35,000 a year less than him. He misled the court. He came in saying, I only make $92,000 a year. And then he had to admit, well, yeah, I work for elections, and when there's elections, I get a lot of overtime, and it's well over $13,000 a year. She's at $35,000 less than him. If you look at relative earning capacity, this isn't equal, not even close to equal. If you look at her contribution, she was the homemaker, the chef, the nanny, she did it all, and what did he do? He complained, she complained he did not help around the house to raise the kid. That was his grounds for divorce. And I guess I would assume that probably had legitimate basis to argue him not doing anything around the house. When you look at the multiple affairs, fault is a factor. He told her, I'm gonna go clear my mind and just get out in the woods. So he goes out to see his girlfriend, spends marital money, go out of state, spend time with his girlfriend to clear his mind. He tells her, I'm going to a counselor. We're doing Zoom counseling during COVID. So instead of doing Zoom counseling, goes to the down end of his driveway and calls his girlfriend. When he gets called at that, he goes to trial and says, well, that was to work on our marriage. He literally said that. He's talking to his girlfriend and trying to explain to the judge, well, I lied to her, but I was working on the marriage at the time. If you look at relative fault, the transfer of 55 acres with no consideration to his parents, when you look at her contribution, his dilatory tactics, he never answered the amended complaint. He didn't disclose the conveyance in his discovery. He had to be forced to finally admit, well, I lied about that. I didn't include it. He didn't try to refinance the property per the court order. If he had to refinance, we may not have had the issue, but he didn't even try to refinance it like he was ordered to. The $500,000 number came to was a document that he put down. It might be worth estimate $500,000. We don't know if that's net or gross. Is that equity, or it doesn't say. It wasn't introduced for that purpose. It was introduced solely to show that he made an application. When you look at the Zuski opinion, I would probably botch the name up that way. The court is given a lot of discretion, and an affidavit was filed in compliance with the Supreme Court rules and right versus right, and they never challenged it. Not one time did they say, we don't think this is a legitimate time, this legitimate amount. You could not have worked on this day. You were out of town. Anybody can do a letter in 10 minutes. It doesn't take 3 hours to do a letter. They didn't contest one item in that at the trial or even afterwards. So as a result, we respectfully request that you affirm the court's decision. Are there facts to support it? Yes. Could have been tried better. Judge Armstrong, I'll agree with you, probably could have been. But it wasn't. And this is what he brought to the table. I don't know what the property value is worth. I don't know what this is worth. I don't know what this is worth. I have no idea. And now they're kind of running and scrambling and trying to cite things that aren't in there to cover their positions today. It is our position that this appeal is frivolous. Mr. Pate acknowledges credibility findings are pretty tantamount conclusive with this court. Because I can say, yes, I had sex with that woman, or I could say, yeah, I had sex with that woman. Pretty much the same words, but you could tell one had a different connotation based on what exactly was said. Chancellor looked at them, looked at my client, looked at when she made statements that hurt her case. She says this is worth more than what he's claiming it's worth. Looked at his dilatory tactics, looked at him lying in his discovery, looked at all of this, and they want to then come out and say, I have a reasonable chance of success on appeal. We would respectfully submit when you don't follow Rule 7, you don't put down the court's ruling, you make cites that aren't covered, and I respectfully request you go through our brief and look at where it says they cited my client's attorney's affidavit as a proof of their value. It has nothing to do with what they cited. They did that on multiple occasions, And with a credibility finding, there's evidence there to support the court's ruling. So we'd respectfully request you affirm the ruling and grant her attorney's fees for this appeal.
Thank you, Mr. Hornsby.
Thank you, sir. Have a wonderful day.
Mr. Pate?
I know my time is very brief. The issue that council raised regarding the 55 acres transferred by the husband to his parents is a red herring, and that case was tried before Chancellor Cox, and Chancellor Cox ruled in the husband's favor, ruled it was not marital property. So irrespective of the value, it was not part of the marital estate. Number two, the husband did in fact testify, I think on this, maybe on redirect, in his opinion, that the 16 acres and home was worth $500,000. So we have wife's opinion, we have husband's opinion, but we do have the bank closing statement that says $500,000, clearly supporting husband's opinion. Apparently the court simply discarded that. And Judge Armstrong—
How do we know if that's gross or net?
That was a gross value, but the payoffs were not in dispute of the mortgages. So the equity is clearly mathematically calculated once we know the value. But Judge Armstrong, you made an excellent point, and I've discussed it with my partner, Ms. Knott. What the trial court should have done, in lieu of saying, well, the value is $817,000, is simply order the home to be sold, and whatever the sales price brings is the value of the home under the classic definition, obviously, of contract law. Willing buyer willing to pay and a willing seller willing to sell. And let that be the value of the home and give wife 60%. But otherwise, the court just arbitrarily says 800 and something thousand, we go with the wife.
But didn't the court give the husband the option of keeping the home and refinancing?
I think he did.
Because the husband indicated
Husband is unable to refinance the home totally, and still
well,
today.
but the court gave him that option.
I think that's in the record, yes, sir, but
He said you've either got to sell it or refinance it to get the wife off of the debt.
Right, and he couldn't refinance it, could not refinance it. And again, the forms that were filed with the trial court and the forms, the original, proposed division of the estate, original and the amended, I think accurately show the clear division of the estate. If you look at all of the record in totality, it clearly is erroneous, and the court did not equitably divide the estate. And again, the issue of the credibility was sort of, in plain language, the kiss of death for husband's argument. And that was sort of the end of the case, so to speak.
All right. Thank you, Mr. Pate,
Yes, sir.
and Mr. Hornsby for your arguments. We'll take this under advisement.
Thank you, Your Honors. Thank you.